Welcome everyone to the first Ask an Attorney for 2021. Today we're going to be talking about multiple offers. Our presentation is brought to you by the Realtor Attorney Committee, Joint Committee for RASM. But before we begin, I'd like to announce our sponsor, Paula Schweitzer with Union Home Mortgage. Paula, take it away.
Thank you, Sylvia. I appreciate you having me here today. I am sporting my green, if you can see too, for St. Patrick's Day. So that was not a mandatory requirement. So thankfully I had some green in my closet. But I'm a local lender in Sarasota. I've been downtown for 18 years. I spent the first 10 years of my career in-house of Michael Saunders doing their financing. So I have a great appreciation for how hard realtors work and attorneys, and fortunate enough to be able to know Erin and work with her through many transactions for many years. We do everything from FHA to VA to conventional to jumbo loans. We have a bridge loan product right now, which is interesting, which a lot of lenders don't have. So feel free to chat and contact me with any questions. I'd be happy to answer anything for you. I think going into the market right now, one of the biggest challenges that we're seeing out there is appraisals. And we do have a local panel of appraisers that I have taken no matter what company I've been with. They are the best of the best. So we're having a lot of luck with appraisals. Knock on wood. I don't know if that's going to be a little bit of a hindrance in the future, but I know Erin's going to speak about that as well. And a couple things we're doing to compete with the cash offers out there is we are shortening some time frames with the contingencies. That seems to be working a little bit well, and getting the appraiser out there immediately so that we don't have any lag time because they're taking a little bit longer. So that's important to be doing. Prior to lending, I was at various brokerage firms, Merrill Lynch, Smith Barney. So although I work with many first-time homebuyers, I also speak very well in that high net worth area, which is great with creating trust income, IRA income, talking to people about leveraging their assets, using margin. Can they secure the assets that they have to buy a house, pay cash, maybe finance it later? So we have a lot of great conversations with our borrowers, and anything you have question-wise, please feel free to reach out, and I'll turn it back to you, Sylvia.
Thank you for your sponsorship, for your support for RASM. We really do appreciate it. Today you will be hearing from two fabulous attorneys, Erin, Christy, and Lisa Moore, as well as yours truly. We're going to be talking about multiple offers, the do's, the don'ts, good business practices, and some helpful hints so that multiple offers don't become multiple migraines. My name is Sylvia Golden-Norris, and I have the honor and the pleasure of serving as RASM's legal counsel now for 20 years. I'll be doing part one of the presentation. I'll be addressing the Code of Ethics, Chapter 475, Stellar MLS rules, and the listing agreement for the listing agents. As a brief reminder, there are a couple of handouts. You will find them in the chat room, and if I recall, it's the Google Drive link. I think I got that right. So there will be a handout from me, and I believe also from Lisa. Part one, after our presentation of part one, which I will be doing, there will be an opportunity for you to ask questions and answers. The chat room will be monitored by the lovely and very talented Erin Christy, I believe. She will be reading the questions and I will be addressing them. There will also be a Q&A after the part two presentation, which Erin and Lisa will do together. They will be addressing addendums and current provisions that are in the market that they're seeing regarding appraisal addendum gaps, as well as price escalation clauses. Full disclosure, because you would expect this from three attorneys, we are going to provide you with a brief summary of all the issues and topics today in our allotted time frame, which may not be everything, but we are not providing you with legal advice. Okay, I think I've covered everything, so we'll just get started. Let me do my screen share here and see if I am competent. Here's the real test. Okay. Can everyone see the screen share? Yes? Erin, are people able to see that?
Looks like, yep, people say yes.
Okay.
All right.
Okay, so the Code of Ethics has 17 articles. Today, we're going to talk about two of them, 1 and 3. Article 1 is what I refer to as the Mac Daddy or the Mac Mommy article, and here's why. It's one of the most common cited articles when an ethics complaint is filed. It also has the most number of standards of practice and the most number of case interpretations. Today, we're going to talk about 5 of the standards of practice because they all relate to multiple offers. Candidly, a lot of the heavy lifting in multiple offers goes to the listing agent, but there are definitely some helpful hints and some good business practices, as well as some required disclosures that those working with buyers are also going to have to remember. And I'd like to start out by saying, often I find out that when there's an ethics complaint, a buyer or a listing agent, a buyer's agent or a listing agent will say, I didn't realize that this was mandatory. Everything I'm going to tell you is mandatory unless I tell you it's not. So Article 1 tells you what your obligations are, regardless if you are working with the buyer or you're the listing agent. And that is, primary job is to protect and promote your client's interests. When I teach the code of ethics, I'll ask folks, okay, so you have to represent your client's interests, you have to protect them, you have to promote them. How do you have to treat everyone else? Often, about 50% of the class will say, honestly. The other half will say, fairly. When it comes to the code of ethics and working with your client or customer, you have to treat the other side honestly, not fairly. And that's an important fact to remember, especially those working with buyers should remind their buyers that it's not always a fair process. It's an honest one, but not a fair one. And I'll explain that in more depth. Standard of practice 1-6 is that requirement for both sides. You are required to submit all offers and counter offers objectively and as quickly as possible. We are finding in this multiple offer situation, lots of moving parts and things move swiftly. You do not want your buyer to miss out on something because you weren't paying attention to the deadline or you didn't respond quickly enough. Make these multiple offer transactions at the top of your list in terms of responsiveness. You have to submit the offers and counters offers. You have to do it objectively and quickly as possible. The contract says time is of the essence for the buyer and the seller. It really needs to be time of the essence for you too. Standard of practice, did I do that one right? Sorry about this. Listing agreement, this has 3 provisions in it. Listing agreement, you are required to submit all offers and counter offers until closing, unless it's waived. Now, I know those of you who do a lot of listing will say, well, they have the listing agreement and they've checked it off that I am not required to do that. I will tell you for reasons, and I'll probably repeat myself, you are going to want to submit every offer that comes across in a multiple offer situation. And you're going to want to do it throughout the whole process. And I'll explain in more depth in a little bit. The next part is relatively new. It's called the confirmation request. Buyers, agents, wake up, wake up. This is your time to shine. If you are wondering whether your offer was presented, you have the ability now, since I think December 2020, this is a relatively new addition to this standard of practice, to ask the question. However, you can't pick up the phone and ask the question. You have to write the question. Has to be a written inquiry to the listing agent. Please confirm that you submitted my offer to the seller. Now, once you do that in writing, the listing agent now is equally obligated to respond in writing. The listing agent has 2 options. First, they can say, yes, I did, it was submitted, or 2, no, I didn't, because that obligation was waived by the seller. If you're the buyer's agent and you demand, I want to hear an answer or I want a written answer from the seller, it's not going to happen because that's not what the Code of Ethics requires. So don't ask it. Is it a perfect solution? No, but it gives you an opportunity to at least make a written inquiry and to get a written inquiry back. If the listing agent refuses to put it in writing, then you just need to note that in your file. And I'm going to talk about documentation in a bit. The last part of this is called seller sees the greener pasture, which is perfect for today. So the seller has accepted one offer, but a better offer comes in. And I mean accepted like they signed it and they delivered it. So it is a fully accepted offer, binding offer. What do you do if the seller gets another offer because you've been doing your job and presenting additional offers that may have come in? First thing you are required to do, listing agents, required, not an option, mandatory, in writing, tell them to seek legal counsel so that they are not legally obligated on two contracts. The only exception to that rule for listing agents is if it is made a backup offer. Standard of practice 1-9 is what we refer to as the confidentiality provision. First and foremost, Florida is what we refer to as a forever state. That means from the beginning and even after the representation is concluded, you are obligated under the code to preserve the information that you received that is deemed confidential. You also have to preserve it, and you cannot reveal it or use it to a client's disadvantage. We're going to talk about confidentiality agreements in a moment. So what is confidential? I'm going to reference the transaction brokerage law because that's what most of you are. It is the default in Florida. Under 475-278-2F, limited confidentiality, and it's pretty much four things. You can't reveal that a seller will take less than what they're asking for. You cannot say that a buyer will pay more than what they've offered. You cannot disclose financing terms. You cannot disclose the motivation of either party and any other information that a party has asked you to make confidential. Okay, standard of practice 1-13.5. Buyer agents, wake up. This you should be doing when you start working with a buyer, and especially in today's market because it's a hot market and you're likely to find yourself in a multiple offer situation. You have an obligation, mandatory, to advise your buyer that their offer is not confidential. The existence, the terms, the identity of the person who's making the offer. The only way it becomes confidential is if the buyer has requested and the seller has signed a confidentiality agreement. One caveat, I have seen confidentiality provisions in an offer. That's not going to cut it, folks, because if it's in the offer, the seller has the offer, the seller hasn't signed it, thus they're not obligated to that confidentiality provision because you've incorporated it into the offer. So don't do that. If it's important to a seller that their identity, we have lots of famous people here wanting to move to Sarasota and Manatee County, you want to make sure that you have that conversation and if a confidentiality agreement that one is obtained. Standard of practice 1-15. This is called the multiple offer inquiry provision. First and foremost, buyers, folks working with buyers, a listing agent has no obligation whatsoever to tell you it's in a multiple offer situation. It's your job to ask the question, so make sure you do. Now, while you are not required to put the question in writing like you are with, did you submit my offer? I would tell you to put it in writing anyway, because again, we're going to talk about documentation very soon here. So put it in writing and ask if there's a multiple offers on the table. Once you do that, the listing agent is now obligated under the code to go to the seller and ask the seller's permission to disclose a multiple offers. First and foremost, I've asked around and sellers are okay with disclosing that because they want to get a lot of offers on the property. One exception to that is if someone has signed a confidentiality agreement. So we're going to talk about that. If you get a confidentiality agreement, as a listing agent, you want to make sure you make that notation so it cannot be disclosed, even the existence of it, if an inquiry is made by the cooperating agent. Are there multiple offers? So if you only have one other offer and it happens to be tied to a confidentiality agreement and you're asked to disclose it, the answer is no disclosure. Now, assuming the seller says yes, that you can disclose the existence of multiple offers, it goes back to the cooperating agent for question number 2. Question number 2 is, so who were these offers from? Because that's important information, isn't it? Is it a buyer that's being represented by the listing agent? Is it a buyer that's being represented by the listing agent's brokerage firm, another agent in that same brokerage firm, or is it a cooperating agent? Once you ask that question, the listing agent must tell you who those other offers are. They must tell you. They don't have to go to the seller to ask permission for that. That is an automatic trigger. Article 3 is what we refer to as the cooperation statute. I call it cooperation, love, and compensation. The listing broker must always disclose variable rate commissions. We've had some incidences whereby the listing agreement contains a variable commission scenario. For example, if the listing agent or even the listing brokerage firm, there could be a different compensation offered and they fail to put it in the MLS. That's a problem because now you violated the code and you violated section, I think it's 9.6 Stellar MLS rule. So remember, if you have a listing agreement and at that time you want to double check, I looked at the Stellar rule and there is the listing, it says listing type, and there is a specific box you must check. Also, if you are a cooperating agent working with a buyer, when you look at the MLS printout, you will see a blurb there under the realtor information that says dual or variable compensation. You want to make sure to look at that. You can also ask at any time you can ask, because sometimes it is the case that the agent didn't have a variable rate commission when they took the listing, but it comes up. So the important part is that the listing agent is required to make that disclosure as soon as practical, So it doesn't have like a definitive within 2 hours, but I'm telling you, time is very much of the essence. Listing agent, once you have done that, your job is done. Buyer's broker agent, if there is a variable rate commission, you need to ask what the variable rate commission is. You need to ask that. And if you're a buyer's broker agent, meaning not just a cooperating agent, but you have a separate agreement serving strictly as the buyer's broker agent, you also need to address with them variable rate commissions before they submit an offer. The Stellar MLS rule, which is a nice thing here, pretty much mimics the code of ethics. It's the same process. You have to disclose it. The listing broker, they tell you by key code, symbol, or the MLS rule, and it just provides that you have to do that. So it's pretty self-explanatory there. Listing agreements. There are provisions in the exclusive right of sale listing agreement for transaction broker. Paragraph 6E says, seller authorizes the broker, 1, to withhold verbal offers, and 2, to withhold all offers once a seller has accepted a sales contract. I'm going to tell you, I don't care if those boxes are checked. I think the best practice is to still submit every single offer that comes to you, regardless when it's submitted, regardless in the manner in which it's submitted. First and foremost, I want to go back here. Let's go back. Sorry about that. I don't want to duplicate. Let's do this. So at the end of the day, a verbal offer, we all know, is not a binding contract. 2, you cannot force a buyer to put an offer in writing. The seller can say to you as the listing agent, tell them I'm not accepting, I'm not even considering anything, I will not respond to a verbal offer. The seller runs the ship when we're talking about how to handle the multiple offer situation. What you don't want to happen is to the seller to choose an offer, close on the offer, and then find out later that a verbal offer was higher, or that even after they accepted an offer, a higher offer came in. And we're going to talk about some scenarios in a moment. Documentation. If you've ever taken a course from me before, this will not come as a surprise. Document, 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 and he or she with the most documentation wins. So in this case, I would submit to you, regardless of what side of the transaction you're working on, there's some key things that you need to document because it's an insurance policy. Key information. How did the seller want the offers presented? And we're going to talk about that. What order? Highest and best. Who presented the offer? Was it the listing agent? Was it an agent working with the broker? Was it someone in-house? Was there a confidentiality agreement? That one's super important. If so, you want to flag it to make sure it never is disclosed. The seller's reasons and objectives in deciding to take one offer over another. That's important. We're going to get to some Q&As about fair housing. So that has a couple of reasons why we really want to do that. If verbal offers are made, when was that communicated to the seller and how did the seller want you to respond? If an agent says, hey, an offer is coming, they don't tell you anything about it. They just say, one's coming. What did you do? Did you discuss that with the seller and what did they direct? Why are these things important? And these things also apply to the buyer. So let me give you a couple examples there quickly. If the buyer wants to know if their offer was really submitted, buyer agents, I've told you, you got to ask the question, you got to ask it in writing. That's part of the documentation that you'll want to keep in the file so you can show that you did that. Another thing for buyer's agents, did you ask about the multiple offer situation? Did you ask about the variable rate commission? Did you ask who was bringing those other offers? Those are things you're going to want to keep a log of. Now, in terms of logs, I always tell people put the date and do it when the event happened, not 3 days later. In the multiple offer situation, though, I would tell you it's really important to put a timestamp. It doesn't have to be anything fancy like we lawyers tend to do. It can just be a quick little script. You'll look at your clock and say it came in at this time and this date. Why are these things important? First and foremost, it's evidence that you actually did what you were supposed to do. You protected and promoted your client's interest, whatever that is. It shows that you were objective in how those offers and counter offers were presented. It shows that you were timely in doing that. And the disclosures that you needed to make, you did. Pros and cons. I'm looking at my time here. Pros and cons. Before, in today's market, you're going to have some multiple offer situations. So have the conversation at the time you're taking the listing. Discuss what the other options are. And again, the seller makes the call, not you. But make sure you document how the seller wanted it handled. The seller can accept one offer and reject the others. They can reject all the offers. They can work with only one offer and reject all offers. Or they can say, bring me your highest, bring me your best. You need to explain. Some buyers may walk, they may not resubmit. So there are some negative aspects of that. So you need to make sure as the realtor representing your client's interests that those are options. You can share with them what your experience is, that you can't guarantee what a buyer may do in response to a highest and best, for example. I'm not going to get into the price escalation clause because you have two brilliant attorneys who are going to be talking about that. The only thing I would note that remember Article 13 prohibits you from practicing law. If you did not go to law school, if you did not pass the Florida bar, if you do not have a Florida bar license, do not write those clauses. They have a lot of considerations, which Lisa and Erin are going to share with you. I just want to caution you with that. Okay, we're going to talk about buyers. Okay, so the 4 scenarios. Let's say the seller accepts one offer and discusses it with the buyers. They say someone else. So I wasn't one of the chosen people. What do I do? You, representing the buyers, can say, you can make it a backup offer or you can walk away. The seller rejects all offers. Buyer, you can submit the same offer. You can walk away. You could submit something else if you want. The seller works with only one person and they reject the others. And there's a really important point here. A realtor I was talking about said what they do when an offer comes in and the seller rejects it, they write the date, the time, and the word rejected on it. So it's very clear. So that's a helpful hint from the realtor community. If they're doing highest and best, you can resubmit your same offer, probably not going to go anywhere. Submit a new offer with different terms and condition. Submit price only change. You may have the price escalation clause, which again, Erin and Lisa will talk with you about, or you can walk away. Most important thing to know about the price escalation clauses, the forms are not, there's no Florida Realtors form, not likely to be one. You are not an attorney, don't practice law. Make sure the buyer gets legal counsel. And remember that the price escalation clauses only deal with pricing. So when you're doing the multiple offer and you're representing a buyer and you have up front a price escalation clause that you've worked with Erin or Lisa and made sure it's all tight, remember that the only thing you're addressing in that price escalation clause is price. And there may be other factors or objectives that the seller values. Okay, who's presenting? In most cases, the listing agent will be presenting the offer to the seller, but buyer's agent, if it's important to you and your buyer, you can ask that you present the offer yourself directly. You're still going to be in company with the listing agent. If the seller says no, the answer is no. You will submit the offer and the listing agent will present it for you. If it is the case that the seller says, yes, I'm okay. And by the way, listing agents, you don't make that call, the seller does. So let's say the seller says, sure, I'm fine if they want to present their offer. You're going to be here with me. The only offer you should be discussing in the multiple offer situation is that buyer's offer. You're not disclosing other information on other offers. If it's the case that either the listing agent has the buyer or some other associate in the same brokerage firm as the listing agent, you're going to want to call in the troops. You want a third party, because while there is absolutely no prohibition against a listing agent presenting an offer by the listing agent's buyer, client, or customer, it's not a good idea. It's really hard to convince folks that you were able to do so in an objective manner. We can solve that problem very easily. You bring in a manager or another agent in your firm to do that. I'm going to talk about 4 myths. How are we doing on time? Are we doing okay on time? 4 myths. Verbal offers, they don't need to be presented to the seller. You heard me say that. I don't care if they check that little box or not. You are much better served by going back to the seller and saying, I know you checked that you didn't want verbal offers. I'm just confirming that's the case because a verbal offer came in. My guess is the seller is going to want to hear it. If they tell you no, great. You just mark that in your documentation. Again, you can't force a buyer to put an offer in writing, but a seller can say, if they're not willing to put it in writing, I'm not interested. Again, sellers can be very angry with their listing agents, even though they were very happy with your services, if they later find out a verbal offer was higher at a higher price. After a seller has accepted an offer, I don't have to submit any other offers received. Yes and no. The better practice, your insurance policy, in my opinion, is to present that. Again, even if they check the little box saying that you could withhold those offers. What's the worst thing that's going to happen? They're going to say, nope, not interested, or they may be interested. The seller can even do so after they've accepted an offer. If they do that, the listing agent, again, you simply have to put in writing to them not to do so until they've spoken with legal counsel, unless it's a backup offer. The seller could have an opinion like, you know what? I'm going to venture a guess that buyer number 1's not going to sue me and I'm going to accept buyer number 2's offer. I don't care. Or they could say, this other offer is worth so much more money, I can buy out buyer number 1. And while it's rare, it does happen. Last 2 questions. I'm the listing agent. I get a call that another listing agent has a potential offer. What do? You pick up the phone, you email your seller as the listing agent and say, I've put on notice that there's a potential offer. Doesn't even have to have any of the terms like price. What do? The seller makes the call. The seller can say, you know what? Tell them that I'm in a multiple offer situation and this is the deadline if they want to submit it. If not, whatever. So the only thing you have to be really careful about there are what are the deadlines for countering or responding to an offer, to include accepting. If the seller wants to accept an offer, you need to be really careful that you don't miss that acceptance date because you're waiting for some potential something that may or may not happen. Offer has to be presented in the order they received. This is probably one of the biggest fallacies. You know, logic may dictate that that's a really good idea, but there's no rule whatsoever that requires it. The seller runs the ship. The seller drives the bus. The seller will make the decision. You as the listing agent will provide them with your big, beautiful brain and your good counsel, but ultimately it's their decision. At this time, we'll take questions, and we were submitted with 2 questions in advance of the seminar, so I'll do those really quickly. The first one is, could the seller accept an offer that does not have the highest price? The answer is yes, absolutely, Because again, the seller decides what is important to them, what their interests are, and your job is to protect and promote that. So price, while very important, may not be the most important thing to your seller. So they could accept a lesser price amongst 3 or 4 offers. The second question is, would it be a good idea for a buyer's agent to include a letter or personal note with their offer, knowing that it's the seller's market? Well, folks, we're introducing ourselves now to Article 10, which is the fair housing article. It goes beyond the scope of today's presentation to get in depth of that, but here it is in a short little segment. Article 10 stipulates that realtors cannot discriminate and cannot be a part of a discrimination process. So some brokers, listing brokers, are putting in the MLS or telling any buyers or buyer agents, those cooperating agents who are working with buyers, that their sellers will not accept any personal letter or notes. And the reason is sellers are obligated under the fair housing rules when they're working with a realtor. And the realtors don't want to expose themselves to a fair housing claim because of something that may have been written in the buyer's letter, sharing that they have children or an age or their race, whatever the case may be. So they say, we're not even going to go there. We're not accepting them. We also know that sometimes a buyer's agent will simply include it without asking or without telling someone that the buyers are submitting a letter. And typically what's happening is the listing broker is crossing it out and put on it, did not review, not submitted to seller, because they've already had a conversation with their seller, the reasons why buyer's letters are not being accepted. That's it for me, unless we have any questions, Q&A. Erin?
We do have a few, and I will say that I am not a litigator because I'm terrible at reading and listening. So I was trying to monitor the chat. If you've already touched on one of these questions, if you
Sure.
could just say, touched on a little bit as a reminder, fill in the blank. So the first one is, can you touch on the honest representation when representing both parties a little bit?
Yes. So if you're representing both, you're going to be a transaction broker, and you need to refer to those obligations that I referred to in the statute 475, 278, and it says the limited confidentiality. You can't disclose what a seller would take other than the listing. You can't tell your buyer, you can't tell your seller, oh, the buyer will pay more than the offer. And you can't disclose any issues regarding the financing or anything else they make confidential. So you have to really be careful how you handle those situations.
Thank you. So going to the variable rate, what happens if the listing agent does not check off the variable rate, but it was in fact variable?
Ooh, that's not so good. Ultimately, I am not a realtor. If a code of ethics complaint were filed, there'd be a problem, certainly, as well as a violation of the stellar MLS rule. The key component there that you'd have to look at is the requirement is to disclose the variable rate as soon as practical. So the person who didn't disclose it would have to reveal and explain when they disclosed it or why it wasn't disclosed. And the powers that be, I am not that person, unfortunately, stellar MLS or your professional standards would make the call whether or not that was a violation.
This will probably be, this is kind of to all of the attorneys. Somebody said, we got an example of an escalation clause from a local attorney in an email newsletter. Are we okay to use that verbiage in the additional terms area of the contract so long as we don't change it? I would say to this, I mean, if you are writing anything in the contract, even if you've gotten it from an email, e-blast source, that is also, I'm sure they have a disclosure that says that's not intended to be legal advice. And I would still, to CYA, and engage an attorney to help you vet that for your buyer or seller's needs. And I'll get into that a little bit in my appraisals, and Lisa might too, but just each situation can be nuanced. So I think take any advice that you get in a mass email with a grain of salt.
I second that motion.
Okay.
Darn it.
This is another question. What's the benefit of knowing who the other agents with the offers are? Also, if the other agent wants to know who said, I have to tell you what my commission reduction amount is, or who brought another offer? You might understand that question better than I do.
Okay, so I think what was being asked is, why would I care to know who's bringing the offer? Because it is frequently the case if on a listing, when there's a listing agreement signed, that the seller and the listing agent may have a conversation. Well, because the listing agent could say, it's conceivable, I could bring a buyer to you, or someone in my firm could. And the seller's like, well, I think I should get a reduced commission. So you're going to want to know, because that's going to be less out of pocket, right? That the seller will have to pay in the commission. And it may then serve to make that offer more favorable to the seller because of the seller's finances and how the numbers play out. The variable rate commission, it's just mathematics. So you just need to know, and your buyer, you want to disclose that to your buyer if you're working with, if you're a cooperating agent, so that they're aware of that. I mean, it's a fact, it's coming into play. It's good information, and information is power.
Okay. So this question is, could it be in the best interest to let all the agents who have made an offer in a multiple offer situation know what the offer amounts were, so that their buyer could bid higher if they want to? They were asked this by a customer this week.
So you're saying I think what's being said is the listing agent is being asked, the listing agent's asking me, is it a good idea to tell everybody what those offers are? Is that, can you read it?
Is it a good idea to let all of the agents know what the offers are, if there's not a confidentiality agreement, for example?
If there's not a confidentiality agreement, there is no prohibition against shopping offers. And that example is kind of a shopping offer. It's like a global shopping offer. It's pretty objective because you're telling everybody, you're not just shopping it to 1 or 2 people out of 4, you're giving it to all of them. But ultimately, that is the seller's call. If the seller says yes, you put that in your documentation. Seller told me to disclose all the offers or the prices or what have you.
And so a buyer's agent could ask for all of the offers, potentially?
I'm sorry, Erin, can you say that one more time? My apologies.
So this person was representing a buyer, is my understanding. Could a buyer's agent ask for all of the offers rather than a listing agent offering all of the offers? Do you see the difference?
A buyer's agent can, they can, but the seller may say no. They can ask about, first of all, the buyer's agent, an agent working with the buyer, has the ability to say, are there multiple offers? That's under that provision of the standard practice I referenced. So they have that ability. Are there multiple offers? Once they go to the seller and the seller okays that. So again, if the buyer's asking, the buyer's agent's asking that, or the buyer, the code says buyer or buyer's agent, the listing agent has to go to the seller, can't make that call, has to go to the seller and get approval from the seller first. And then the seller can say, yes, I'm disclosing the existence of other offers. If the buyer said, I'd like to see the offers, the seller can say no or yes. I mean, the seller can shop offers. The buyer's agent can ask, but the seller is going to make that call. The buyer's agent can't ask and say, well, you have to give them to me. You don't. The seller is running the bus, steering the ship, whatever you want to call it. It's a seller's decision, but there's nothing prohibiting that.
Great. And then I think we have time for one more, and then we'll try to come back to them at the end of Q&A. This question is, can you call for highest and best prior to receiving multiple offers? Since you are expecting multiple offers, can you call for that at the beginning?
If that's what the seller wants to do, I think the only caveat there is that the listing agent saying highest and best before they receive, but they anticipate, like they've been told, I'm assuming they've been told. You don't want to misrepresent that you have high, you don't want to misrepresent, because that's going, if no one said that they're going to submit an offer and you say highest and best, that's a misrepresentation in my opinion. But if you have people calling or emailing and saying, we're going to be submitting an offer, certainly you can start off saying highest and best. And then you would converse with the seller as the listing agent and decide what that deadline is to submit the highest and best.
And then just to cap off, is the listing agent obligated to tell how many offers are in a multiple offer situation?
It's a two-part question. So part one, these are great questions, by the way.
They really are good. We're
Making me think. Say that one more time. So,
Is a listing agent obligated to tell buyers how many offers are in a multiple offer situation?
Is a listing agent obligated to say how many listing offers? First and foremost, the listing agent doesn't even have to say the word multiple offer unless a really smart buyer's agent went to this seminar and knows they have the right to ask the question. So that's the first part of it. The second part is the buyer's agent can say, are there multiple offers? They ask the question. Listing agent goes to the seller again. You got to remember the little steps. Goes to the seller. The seller will say, yes, you can tell them their existence of multiple offers. That's the key word, existence, or no. Seller says, yes, disclose the existence. That's fine. Then they say, okay, buyer, I'd like to know who presented the offers. And so at that point, the listing agent has some ability, they still probably should have a conversation with the seller to say, can I tell them how many? You absolutely have to tell them there are some from my firm, there's some from cooperating agent, and oh, there's one from me. So you have to break down those three segments if they apply. I have the listing agent, I'm doing it. Some other folks in my brokerage firm have, or the cooperating agent. You don't have to give them the exact number, but you have to disclose who submitted those offers.
Thanks, Sylvia. And then just to follow up, there was some follow-up question on just explaining that the escalation clause was from a law firm. We understood that. You can get that in a blog, you can get it in an email from a law firm. You know, I think that it's a good example, but just keep in mind that just because it's a general clause that fits most situations does not mean that it is going to fit your buyer or your seller's particular needs or situation. So anything that you just copy and paste, even from an attorney's blog post or e-blast, you know, that is a type of practicing law. And to CYA, I would make sure that you have an attorney, even if it's that attorney, engage them and ask them to look at that for your particular situation. Okay, we are going to move on to part two, which is me and appraisals. So I will not be monitoring the chat right now. Again, we'll do the Q&A for part two after both I have been able to present and Lisa. Okay, Sylvia, can you please stop sharing your screen and also, okay.
It's all about me. No, just joking.
Okay. Okay, Cassidy, you told me you would say nothing if I was doing it right. So let's hope everybody can see the screen. And so we're going to talk about appraisals. And I am going to go over a little bit, you know, both the appraisal contingency from the financing perspective and the appraisal contingency from Addendum F. Because, you know, I know that we are in a seller's market, but it's still just good to understand kind of what these are, how they work together. And then we can get into, you know, covering the appraisal gap because that really plays into the seller's market that we're finding ourselves in. So when we talk about an appraisal contingency, there's really two different appraisal contingencies that you are working with here. One is the appraisal contingency that is the FAR bar contract Addendum F. And this one protects the buyer typically from being obligated to pay more than the valuation of the property. The appraisal contingency with regard to financing in paragraph 8B, where you are making this contract contingent upon the buyer getting approval, allows a buyer to cancel if they don't get loan approval. And that can be related to an appraisal, but the appraisal does not necessarily tie directly to the purchase price the way the appraisal contingency does. So what I'm trying to explain here is don't assume that just because you checked the financing contingency box and that has this highlighted appraisal portion in it, that you are covered because for your buyer. If the appraisal comes out, and we'll get into this in a minute, if the appraisal comes out not at the purchase price, they may still be obligated to close. If you're trying to protect your buyer to only pay the appraisal amount, you want to use the appraisal contingency addendum F. So let's go over financing a little bit. Again, this only applies if the appraisal is insufficient to meet the terms of the loan approval. So think about the loan approval and what it can be conditioned upon. It could be conditioned upon a number of different things, including a different amount than the purchase price for the appraised value. So you really want to understand what that loan approval says and if it's conditioned on anything. I think we've all seen them. They're conditioned on a lot of things. You really want to understand what it is. Here's an example. If the loan approval of why it might not cover what your buyer wants. If the loan approval is financed for a fixed percentage, the buyer could still be approved for the loan, but at a smaller amount, requiring them to bring a larger down payment. So if that loan approval is not for a specific dollar amount, but is instead for a specific percentage amount, the lender could still give loan approval for a percentage of the appraised value and require your buyer to bring the rest cash to the table. They've been given loan approval and your buyer no longer has a right to just back out. Also an example, if the borrower, your buyer is borrowing less than a standard loan amount. So say they're only getting 50% of the purchase price for a loan. A low appraisal still might meet the threshold for loan approval because so many loans really require that 80% loan to value ratio. And so you might still get loan approval even with a low appraisal amount because they just weren't borrowing that much in the first place. Here's the appraisal contingency. This can protect either a cash or a finance buyer from being obligated to pay more than the purchase price or some other amount that they include here. It sets an exact appraisal amount, and if that appraisal amount is not met, it gives the buyer the option to terminate the contract. It still allows for the financing appraisal contingency potentially outlined under your loan approval in paragraph 8B. Two things have to be negotiated by you as the agents between the buyer and the seller. You need to negotiate the appraised value minimum, and you need to outline the deadline to receive the appraisal. So how do these two things work together? I have some examples here to kind of walk through how you work the financing contingency with the appraisal contingency. Let's say, for example, a lender denies a loan before the loan approval expires under the financing contingency, or appraisal deadline under the appraisal contingency due to an appraisal that doesn't meet the purchase price. A buyer can use either the financing contingency to terminate the contract or the appraisal contingency in this scenario. Scenario number two, lender gives conditional loan approval, but then later on rescinds that loan approval once the appraisal is actually received. The buyer can cancel under the financing contingency because the appraisal was insufficient, and again, going back to this highlighted in part here, appraisal property is insufficient to meet the terms of the loan approval. Or the buyer can cancel under the appraisal contingency only if the appraisal was received by the appraisal deadline. So here's where you kind of get into your protection here outside of the financing. Let's say buyer pays for its own separate appraisal and it comes back below the negotiated value in the appraisal contingency. As long as the appraisal was received by that deadline we talked about you negotiating, then the buyer can cancel under the appraisal contingency regardless of what the lender might approve. So this just gives you an idea if you are representing a buyer or if you're representing a seller and want to understand, how attractive this offer is, how these two work together. I think I have seen oftentimes, a realtor say to me, well, we're getting financing, so if it doesn't appraise, we can just cancel under the financing appraisal in the financing contingency. And that's just not the case in the event that that is not what the loan approval was actually conditioned upon. So just make sure you don't find yourself in that trap. If you have a buyer really set on only paying the purchase price under the appraisal amount, make sure that you have this appraisal contingency attached. So the appraisal gap addendum is is really used, you'll see, to make an attractive offer in this seller-friendly market. And what it's meant to do is make an attractive offer because the buyer will pay some certain amount over what actually gets appraised. I've seen this done a couple of different ways, and we'll go through kind of what's favorable to a buyer, what's favorable to a seller, and each of the elements that you want to see in your appraisal gap addendum when you're drafting one, or not drafting one and having your lawyer draft one for you. So in this scenario, we have a financed buyer, and they make an offer for $500,000, but the property only appraises for $475,000. The lender will only loan 80% of the valued property, which in this case would be $380,000, because it's 80% of the value of the appraisal, not the purchase price that was offered. That $120,000 difference between the purchase price that the buyer said that they would pay and the loan amount that they can get, because they'll only get 80% of the value of the property, needs to be made up in some way. Since the buyer had already planned to put down 20%, really what you're making up in this situation is a $20,000 that needs to be negotiated. Back in a buyer's market, oftentimes we'd see a seller and a buyer negotiate to reduce the purchase price, the seller to give a credit to the buyer for some amount, to make up that difference that the buyer needed to bring to the table, and that would be the end of it. However, in a seller's market, we're finding that it's only attractive where a buyer agrees to pay the difference between the appraised value and the purchase price, again, only up to a certain amount or cap, regardless of the loan amount that they are able to obtain. So here's our scenario again. The finance buyer makes an offer for $500,000 and includes an appraisal gap addendum that says buyer will pay the difference between the purchase price and the appraised value. That difference is called the gap, up to a maximum amount of $10,000. But if the gap is greater than $10,000, buyer has the right to terminate and receive return of deposit. Then your property appraises at $475,000. Option one is that the buyer can waive the appraisal gap contingency and pay the full purchase price and close. You always want the buyer to have that option, especially if they have the funds to do it. Look, I figured out what it was. I still want the property. I'm going to go ahead and make the option to close. Or two, buyer can terminate the contract because the gap was $25,000 and they only agreed to pay up to $10,000 over the appraised value. Of course, option three is that buyer and seller can, come to the table and agree to some other arrangement and put that in an amendment. But as drafted, this is where you are kind of left. So these are some considerations that you want to consider in every gap addendum. So often when I see realtors kind of try to draft their own additional terms, I see them, or realtors try to draft their own additional terms, I see them leave out some of these contract 101, like, okay, you have to do this, but if you don't do this, then what happens? So often that then is left out. Are we just calling everybody in default? What are we doing? What are the consequences if you don't meet the terms that we agreed to? So general considerations are, what appraisal is being relied on to set the appraisal amount? Is it the lender's appraisal? Is the buyer going to go out and get their own appraisal? Can they rely on the can a buyer rely on the lowest appraisal amount? Can a seller rely on the highest appraisal amount if the buyer's going to go get their own? Really define who's setting that appraisal amount. Also define the gap. What is the gap? It's the difference between the purchase price and the appraised value. Again, which appraised value? Lenders, buyers, figure that out, define it clearly. If applicable, define the gap cap. How much over that appraisal amount is the buyer willing to pay? If there isn't a cap, then there isn't a cap. But if your buyer really doesn't want to get subject to having to do $50,000 over in some cases, then you really want to make sure that you don't obligate them more than they are comfortable with. The appraisal deadline. This gets left out sometimes too. When does the appraisal for the gap addendum have to be received? Okay, so first, when does the buyer get it? And then how much time does the buyer have to go ahead and get that to the seller? You see this sometimes in loan commitment deadlines. There are other deadlines in the contract where the buyer gets it first, and then they've got so many days, 3 days maybe, to turn it around and get it to the seller. Same with the survey. Same concept here. You need to make sure there are obligations for delivery to the parties and that there's a deadline. And then what happens if those things aren't done? What happens if the gap, what happens if it's over the cap? Does the buyer have the option to waive the cap and move forward? How many days do they have to do that? Once we know and the appraisal has been given to the seller, do they have to say, I'm waiving it, moving forward now? Do they have to terminate now? Do they have 2 days to think about it? Really define that and make sure that you're giving that notice. And then if the buyer doesn't receive notice, if nobody follows the terms, we're kind of in like a inspection world under the or repair world under the repair contract where everybody's just missing deadlines everywhere. What are the consequences to that? These things really matter because that's where litigation happens. That's where deals fall apart. So really make sure you have a well-drafted gap addendum. Over here in the box, I just kind of put some things to consider if you are representing a buyer and then if you are representing a seller. So if you're representing a buyer, you probably want a gap cap in there so that the buyer is not obligated to pay some extraordinary amount over the appraised value. You want the option to terminate or to move forward, not one or the other. And then the other thing is that it might be wise to have the buyer be able to incorporate that gap amount into their loan, which then increases the loan amount that goes back to the, to the meaty part of the contract and gives them some more flexibility with their financing contingency. With a seller, kind of some of these opposite things. You don't want a gap cap. Buyer must pay the difference no matter what. You want your purchase price. Buyer can't change the loan amount to cover the gap. We don't want to go, messing around with the financing contingency. It can't be financed. They just have to have the assets. Then you want the buyer to represent that they actually have those assets so you can come back to that contract and rely on that. Because you don't want them to say, well, I just don't have the $50,000. You say, well, you represented that you did. You're in default under the contract. I'm getting your deposit. Again, generalizations here. And then finally, you want the buyer to waive the right to terminate the contract or the appraisal, including the financing appraisal contingency. So regardless of the appraisal, no matter what happens, buyer's moving forward and they can't terminate, and tie that back to the financing contingency if there's a financed transaction. So this is it in a nutshell. I will check the chat box while Lisa presents just to try to answer any questions at the end of the Q&A. I am going to.
I did see that there were some questions for you on the chat. I'm going to share my screen as soon as I get this up properly.
Great.
Okay. As soon as I figure out how to share my screen. Okay, I'm sorry. I totally am supposed to know how to share my screen and now I can't find it. Oh, there it is. The big green button. Gotcha. Okay. So everyone can see mine, I take it? Okay. Okay, so the first thing that we can talk about are backup offers. And I saw in the chat that somebody had mentioned the kick-out clause in the Florida Association of Realtors addendum form. So the reason why you might be considering backup offers, obviously this is a seller's market currently. And so from their perspective, if you're the listing broker, you have a seller who potentially has a desire to continue to market the property. I'm seeing some sellers ask about that in the context of many buyers. I know they had been doing this quite a bit in really a lot of last year. And that is with a lot of buyers presenting offers sight unseen, and then wanting the time to kind of do inspections and maybe have friends pop in and see the property in person before they decide whether or not they're going to continue with the contract. And then from the seller's perspective, that helps them not waste any time if that is the situation, and then they can move right on to the next one. We just, Sylvia already did a fantastic presentation about some of the listing agreement considerations. So you just want to maybe consider that your seller's expectations may not be in alignment with some of your responsibilities under the terms of the listing agreement. And you want to make sure that you're managing those expectations, and obviously that you're following the terms of your contract in the listing agreement, your contractual obligations, as well as as well as the rules that govern your behavior. Also, you will want to consider scrutinizing other contract amendments, or I'm sorry, contract provisions that may or may not conflict when you add some of these different types of contractual terms via the riders. So the kickout clause was mentioned, and I went ahead and put it on the slide for you. And that one makes it very clear that the seller has the right to continue to market the property and solicit backup contracts. Just, again, as with all of the writers, you just want to make sure that you're really reading what you're doing and making sure that everyone's on the same page about what it does and doesn't do. I can answer any specific questions about that as we go forward. From a buyer's perspective, you are, maybe you're in a multiple offer situation. That seems, very common at this time. You really want to make sure, if you're the selling broker, that you're managing your date and time frames pretty well. You want to make sure that you are juggling these time frames well, because when you're submitting, maybe you're considering submitting multiple offers and trying to manage the time frame, and what you really want to avoid in this type of situation is having your buyer potentially be obligated under a couple of different contracts. In the same far rider, you will have the backup contract option, which gives the seller the buyer the option of submitting this backup offer and having the seller then slide it into the first place if the first place contract is terminated. Escalation clauses are very much related to the multiple offer situation. Just to give you some background, most escalation clauses are litigated in the context of leasing. So there's not a whole lot of case law about an escalation clause in terms of real estate, residential purchase and sale situation. Just the very basics about the escalation clause, so that we're all on the same page about what it is. An escalation clause is a clause in a contract that allows the purchaser to automatically increase their purchase price based on external factors, which is most likely the competing higher offer. So for a simple example, your buyer is basically saying, I'm going to offer you X for this home, but if you receive an offer that's higher than mine, I'm willing to go up to Y to increase my purchase price. So there was a person in the chat who was referencing another local real estate attorney's email newsletter that had an example clause. And I would caution you in using a blanket email blast form. And the main reason that I would caution you for that is escalation clauses should be used, and we can get into more considerations. Escalation clauses should really be used with caution. They are not meant to be a one-size-fits-all type of clause. It's really a more deal-specific situation when you are going to be using one. And there are some variables that you have to think about, especially in the possible scenario where you have multiple offers with multiple escalation clauses. So the short answer to the question is, even if you are getting the general statement of the escalation clause from an attorney's email newsletter, I would not suggest just putting that in your form bank and then, whipping it out right now because it is, such a hot market. I would definitely want, in the very least, to have a conversation with an attorney that can discuss with you more detail of the nuances of your specific situation. So some things to think about when you're looking at the escalation clause from the buyer perspective. Make sure that you're in a multiple offer situation. The big thing from the buyer perspective is clearly you're showing your hand. Now the seller knows your top dollar. Some of the things that you really want to make sure, Erin touched on this a little bit, and it is what happens if then, if if the thing that you're thinking is going to happen doesn't happen, what happens then? So when you and the attorney are drafting the escalation clause, some of the things that really should be in there, no doubt, are the maximum amount that your buyer is willing to pay. Keep in mind that when you're drafting an escalation clause, you're obligating your buyer to go to that higher price. And so what you really want to make sure you do is define quite clearly what that increase is actually, how that's going to be calculated. And so in an age when seller concessions is also extremely popular, you want to make sure that when your seller is reviewing the multiple offers, they're not just looking at the highest purchase price with some seller concessions. You really want to make sure that you're kind of nailing down that the highest purchase price that's going to trigger your escalation clause is a net purchase price, not including any seller concessions or any other kind of concessions that you're throwing in there, or that the other offerers may have put in there. Another thing that you really want to make sure that you do is to require the seller to prove that they have received this higher offer by providing a copy of this offer. And I know that Sylvia touched on some disclosure requirements from the seller perspective, but note that that is probably going to be the best way for you to protect your buyer. You don't want them just trying to trigger your escalation clause because someone said that they were going to offer X. You really want to make sure that that's what's on the table for your buyer. And then you want to provide a deadline for the escalation so that you're not in the middle of your contract and all of a sudden now the seller is saying, hey, by the way, I got this higher offer, unless that is actually the way that it was drafted in an effort to be a more agreeable offer for your seller. And this is maybe where that backup offer and escalation clauses can kind of commingle with each other. And you want to be careful with that so that your buyer has some point when they know what they're paying for the property. And again, like we already talked about, these aren't really one size fits all. They do need to be a little carefully drafted. From a seller perspective, there's the benefit of seeing the buyer's hand. Some sellers, though, may not be comfortable with this because it can get complicated, especially in a multiple offer situation, especially with multiple escalation clauses or, some desire to continue to accept backup offers and whatnot, or any other contingencies that they've thrown in. So everything that we've talked about today kind of layers on another layer of complication or complexity that your seller may or may not be comfortable with, and they may be more comfortable with just a deadline for receiving offers, and they just want their buyers to put their best foot forward and they don't want to mess with this. So you, from a seller perspective, just have to feel your seller out and know what they're comfortable with and make sure that at every point they really seem to understand what is happening and what they're actually going to be ultimately getting. With, of course, maybe some suggestion that they are represented by counsel. So some other things to think about, a little bit has already been touched on. So clearly mine's going to be the shortest presentation. Thanks for letting me go last. Make sure that when you are trying to add some complexity to your offer, like we've already said, that you keep in mind financing contingencies or appraisal contingencies. All of these things are going to have to work together, and your contract provisions are going to have to be cohesive. You don't want them to conflict with each other, because then you find yourself in a situation in the event of a dispute. And again, I'm also not a litigator, but if you find yourself in a dispute, it's going to be difficult to accomplish your goals when portions of the contract are in conflict with each other. And also remember that when you are in more than one offer situation, you are going to need to really be careful if everyone is trying to do this. And you're going to really need to be careful with how you ultimately get a meeting of the minds with your buyer and sellers, such that when there are the multiple offers and they each may have, some degree of complexity because of the contingencies or the escalation clauses, that everyone really seems to understand the web and how it's going to be untangled so that you don't go down the path of a dispute. That is the end of my slides. I don't know if anyone maybe has more questions than that general 5-second little tutorial that on my part was. So I don't know if we want to dive right into questions or how much time we have left for that.
Cassidy, can you tell us how much time we have left? Because I do have a number of questions here. They're good and would love to address them. I have time if people want to hang out, but.
Yeah, Erin, that's up to you. If you guys want to stay on, it's totally up to you. People are free to leave. It's not a CE class. So if they want to stay on for the information, if you guys are willing to stay, then that's fine.
Okay. Thank you. So one question that's coming up a lot in the chat is, what do you do? It's 9 o'clock at night. You can't get a lawyer on the phone. You can't get your broker on the phone to review your language. I have told, agents and certainly being a real estate lawyer, I have my phone on me a lot because we're kind of running the same crazy hours that you all are because, your clients are our clients or your customers are our clients. But if you can't get a hold of a real estate attorney, oftentimes what people will try to do is make your contract subject to attorney approval. And it doesn't have to be the 3 days. You can shorten that up to make it a number of hours, 1 day, just so that so that everybody understands what's on the table and what your buyer wants to do or what your seller wants to do. But then still leave it in the attorney's hands if you can get everybody to agree. I understand you can't always get people to agree to that, but that is the best situation if you want the attorney to review it or your broker and you can't get a hold of them at the time that it's being made. So Lisa, this is for you, and I know you just kind of touched on it a little bit, but in these days we're seeing a lot of offers with escalation clauses. So maybe one deal has 3 offers, all with escalation clauses on it. How do you deal with the multiple escalation clauses? And that might not, be a quick answer, but.
Well, I think that the shortest answer I could give is this is probably going to be one of those times when you want to be talking to an attorney, because what you're really going to want to do is unpack each offer in its own right so that you can really see how each offer has defined the things that we just mentioned, that we really want defined, so that you can really make sure that your seller is kind of comparing apples to apples, I guess would be the best way to put it. So if you have one offer that has an escalation clause that doesn't define the purchase price as net but you've got some seller concessions to think about. So because of all of that, kind of muddying the waters a bit, if I would want to take the time to really look at each contract in its own right, see how they're defining these things so that your seller is actually comparing, or I'm sorry, your buyer or your seller is actually comparing apples to apples. I think that's the best way that you could really make sure that you're managing the multiple offers with multiple escalations. And either of my co-panelists can jump in if there's anything else that you would do or suggest in that regard, but that's really your best bet.
I would absolutely agree with that. The only additional thing I would say is make sure as an agent, you're not thinking it's only about the price, because as both of these really bright women have educated you, there's a lot of stuff in there. And if you think only about the price and you're thinking, oh, I'll just add up who has the highest price and then the price escalation clause, you are going to get yourself in some trouble. So I think that's great.
And then there was a kind of a second part of that question by a different attendee who asked, what if the offer that the seller chooses is not the highest dollar amount, but maybe they considered it a better offer? I am under the impression the best offer is the one that will close. But are there any ethical standards to that, Sylvia? Does it have to be the dollar amount, or no, the seller can take any offer they want?
The seller can choose any offer they want for whatever their objectives are. I mean, they can decide maybe it's more important when they can close. Maybe it's more important that it's a cash deal and not a financing. So, those are the variables, and the seller gets to make those decisions. Solely the seller gets to make those decisions.
Okay, so when you're expecting multiple offers on a new listing, instead of calling for highest and best, is it acceptable to request offers be submitted by a certain day and time and won't be replied to until the next day? Sylvia, this is for you. And then the second part to that is, what happens if, say in the listing, listing agent says highest and best by Sunday at 8 p.m. Seller will not, accept anything before that. And then they accept an offer and sign a contract on Saturday morning.
Oh, okay. Well, let's take the first one. And my pea brain didn't memorize the first one, but I want to go with that one. That one I think was.
Can you
sorry.
ask for highest and best by a certain date and time and say that it won't be replied to?
Sure. So first and foremost, again, the seller runs the ship, drives the bus, whatever. The seller decides what the seller wants to do. The buyers can say, fine, I'll submit it, I'll play by your rules, or I'm not interested in this game. They can leave. It's their choice how they respond to the seller's parameters. So that can happen. And then part two is that the seller sets the parameters and then the seller changes their mind and does whatever they want and accepts another offer before. Right?
Right. Yes. Yep.
Sorry about that. So that would be kind of a not nice thing to do. It's certainly not illegal. If I were the listing agent, I would say, can we wait and follow this through with everybody? But if the seller wants to do that, there's nothing in writing prohibiting the seller from doing that. And you, as the listing agent, have again the obligation to protect and promote your client's interests. That being said, we have this thing with the Code of Ethics called the Pathways to Professionalism. And as a code instructor, I would encourage you to have a conversation with your seller if that's what they want to do. If they do decide to take an offer and forget that they told the other people or suffer from selective amnesia, then I would ask the seller, then let me tell everyone that you've changed your mind. So at least you're keeping people informed about that. But the seller has the absolute right to do whatever the seller wants to do.
Okay. So kind of just on that highest and best offer kick, for confirmation, if an agent for the buyer asks what the highest offer on the table is, and the seller, the actual seller, agrees to that, then the listing agent can share the dollar amount of what the highest offer on the table is because the seller said they could?
Yes, but there's a caveat there. You can't assume that just because the seller said I can disclose this and I'm going to share this, the offer with you, the highest offer. You got to remember there could be a higher offer, but it's subject to a confidentiality agreement. So maybe it's not really the highest. It might be the second highest. So you can't 100% say that it's the highest because you don't know the confidentiality agreement.
Okay, good point. So on confidentiality agreements, Sylvia, I think right now this is the last question for you. When a buyer's agent, for example, asks the listing agent, why is the seller moving? It can get tricky to answer that. What exactly would a confidentiality agreement entail? And is it smart to have some sort of form that outlines exactly what is confidential? I think examples here would be like employment, marital status, things like that.
Right. Again, 475-2782F is that limited confidentiality. So that's going to provide you with some of those parameters, and those are statutory, those are mandatory. So one of the things you were talking about, the motivation, that's number 3 in this, the motivation of either the seller or the buyer. So you need to have a conversation, whatever your seller feels comfortable with. If your seller says, being proactive in these things is really important. So if you have a conversation in advance, you'll already know in writing. You say to your seller, how would you like me to respond when they ask if you're moving? I mean, you know some of the questions that come up. And if you're asked a question that you don't already know how the seller wants you to respond, then you go to the seller, you get the response, preferably in writing, because if it's not in writing, it doesn't exist, people. You've got to get it in writing. It can be a text, not my favorite, prefer an email. Oh, totally okay with an email. And if it's a phone conversation, then follow it up with an email. This is to confirm you told me I was allowed to share X, Y, and Z information. Some information the seller may be perfectly fine. I'm leaving the state, I'm whatever, but some things they may not be, and it's not your call to make, it's the seller's.
Awesome. I've got a few to answer here. So, and I've seen this on other contracts that have come in that I'm closing, but didn't necessarily negotiate the contract. And it simply says, buyer will move forward with the purchase price regardless of the appraisal. Seller knew or thought that the house wouldn't appraise, so they wanted this in there. Can you talk about this a little bit? And this gets down to the situation of kind of what situation are you in? Buyer will move forward with purchase price regardless of what the appraisal says. Well, if it's a cash deal, look, maybe this one sentence does the job and you're fine, and your buyer doesn't want any other protections. They want to pay the purchase price and they want to go and move in. But if it is financed, you leave a lot of gray area in there that they could still be denied the loan. That may not work in your buyer's favor. And so you were asking from the buyer's perspective, again, if it's, cash, probably fine, not perfect. But again, if you're loan, you really should tie things back to that 8B. If you check the financing contingency, there's so many defined terms in there. There are so many timelines. There are so many things that can be wiggled out of. Merely saying, I'm going to pay the appraised value no matter what, you could be obligating your buyer to pay cash, because if they don't get that loan, they could be obligated to close. If I was seller's counsel, I would have really wanted that tightened up. So if I was the seller, I'd want to say, notwithstanding anything in the contract herein, anything contrary herein, including the appraisal insufficiency in paragraph 8B. I mean, you want to go through and check out every little thing that could be an out. The buyer must close. And then your buyer might be obligated to pay cash. So it really just kind of depends on the situation, which is why I said these blanket things that you get, they're a great starting point, but make sure it's meeting your buyer's or your seller's needs, because you're the one who's going to be on the hook. It's your license at stake, and even a lawsuit if it's unlicensed practice of law. So that's the answer, the kind of scary answer to that one. Hope it turned out fine. How and when do we deliver the appraisal gap addendum when we're in the last hour of negotiations? The appraisal gap addendum should be, in most situations, included with your final offer. So whether that's the first offer and you think it's going to be accepted, you put it on at the beginning. If you're kind of going back and forth and you've got your buyer in a situation that maybe the purchase price is getting a little higher than they want, and they want to make sure that they've got some sort of appraisal gap addendum, in your counter offer that you're going to sign saying, I'm all done with the contract, this is final, we agree to the purchase price, you put that appraisal gap addendum on there, and then the contract's not final until your seller signs that. So it's kind of a little contracts class for you. There's an offer, a counter offer. That counter offer stays open until it's rescinded. So just kind of make sure you know where you are in the contract process. One more question for me. Where do we get these gap appraisal addendum? If your broker doesn't have a vetted one, some do, some have had in-house counsel draft for them, and I know that they're available, then I would engage an attorney to draft, or at least review what you have drafted and get the blessing. You do not want that liability on you for drafting that if it turns out it didn't work out in your client's favor for some reason. So if you want to take a first stab at it, send it to buyer's counsel and say, take a look at this. Does this fit our needs? Let me explain it to you. Plug Realtor Attorney Joint Committee. This is why we recommend closing with a law firm, any law firm, because you have counsel built in. Understand if you are working with a law firm who's the closing agent, who do they represent? Do they represent your buyer? Make sure you have that very clear, and then ask them to represent them and help negotiate the contract. If you tend to work with title companies, you can still engage an attorney to help negotiate the contract and pay them an hourly rate to do that, and close with the title company if you feel a real commitment to them. But oftentimes with a law firm, that's kind of built in when they're a closing agent. Lisa, or maybe a little bit Sylvia, I'm not sure. If you have a backup and it's withdrawn, are you obligated to tell the sellers that?
Do you mean is an agent required to send the rejected offer back to the buyer's agent? I believe, I'm not sure I totally understand the question. Is the agent required to send the rejected offer back to the buyer's agent for a backup offer, and then they withdrew it? Yeah, I would say yes. I'll let Sylvia speak to this too, but I don't think that the buyer, I mean, until the seller accepts it, and this is also just contract 101, until the seller accepts it, the buyer can withdraw it. And, oh, I see. And then do you have to tell your sellers? That I'm going to let Sylvia answer to whether or not you have to tell your sellers about a withdrawn backup offer. And so I don't know if I really answered that question correctly, but I would say that if you have a buyer who submitted a backup offer, the seller did not accept it. And I believe that that backup offer language in the rider specifies this, that without a certain day and time certain that the first contract has to expire, the buyer still can withdraw the backup offer. It's not an accepted, you don't have a full contract yet until that has actually happened. But speaking to whether or not you have to tell your seller about that, I would defer to Sylvia and the rules and what you're obligated to do there.
So if you get in trouble with the code or DBPR, it's typically because you failed to disclose something. There's no downside to you disclosing that an offer or a backup offer was withdrawn. And I think it's your obligation to do so, to tell the seller and keep them fully informed. Even if it says it automatically terminates or whatever the language may be, your job is to protect and promote your client's interests. And it's important for them to know if a backup offer has been withdrawn.
Okay. So here's the question that
I just read the chat.
it says it's
I
for
feel
me,
you.
but I'm not sure. I think it might be better for Sylvia. Sylvia, if there's an MLS listing this and it said that the seller is selling the home as is, but requires a standard CRISP contract, how do you, I mean, one, can they require a certain contract and only accept offers on a certain form? Like I'll only accept an as-is contract. I'll only accept a standard repair contract. Can they do that? First question.
The seller can decide, however, they can absolutely say, I will only accept this contract if it's on, Charmin's double whatever stuff toilet paper. They get to make that decision. Now, the agent working with them should explain the pros and cons of making those, setting those parameters, because there may be some cons. So that seller can pretty much say, yes, I'll accept this or I won't. So.
Okay. And then I guess the second part could be for any of us that just says, the CRISP form. So say they want a certain form, but they're selling it as is, and that form, I don't work in the CRISP form enough to know off the top of my head. That form doesn't necessarily sell it as is. If they really want to sell it without making any repairs or things like that, these things have to be carved out. You have to understand what exactly it is that they're asking for. Are they asking that, after 15 days, they can't back out for any reason? That needs to be addressed, and be very careful mixing and matching these forms and addenda, because the paragraphs don't always line up, the defined terms don't always line up. So if you're using a FAR bar as is contract, or if you're using the CRISP contract and then trying to attach kind of FAR bar addenda, that might not work. So I'm a little confused by the question, but the answer is, make sure you understand what all the parties want, and then carve those or draft those and have an attorney draft specifically for what the seller's trying to achieve and the buyer's trying to achieve, to make sure that's what's happening. Okay, LL, I'm gonna try to address this offline because you're asking me to look at lines 106 through lines 110 of the FAR bar contract, and it reads that the buyer can walk if they do not get a commitment before the loan commitment date. I'll get into the financing contingency nuances 101 offline. Okay. Can a seller request the buyer use a certain mortgage company in order to accept? This kind of came up in another question where it said, can a builder tack on an additional $3,000 fee? Paula, maybe these are questions for you. Can the seller tack on an additional $3,000 fee if they don't use the builder's lender, or are you violating, kind of TRID and other regulations there? Paula, do you know the answer to that off the top of your head?
Well, I would say that you can't steer anyone towards one particular lender. So, I mean, even in new construction, It feels like it because if you don't use them, you know, you're not going to get the $10,000 credit or whatever. But I bet you if you go to New Home Communities, they're giving out the name of more than one lender because they don't want to have it look like steering. So I would say a seller could probably say maybe the names of a couple lenders, but they can't steer it towards anyone in particular. Does that answer the question?
And I think that probably answers the question where the seller is like a builder and the lender. But what about where it's just a private seller on the resale market? Can they say, we only want you to use Paula Schweitzer or we don't want to close with you? Sylvia, is that the seller can do whatever they want?
I mean,
I think that
No,
is,
yeah, with no penalty involved. This is a different situation.
I think that exceeds my skill set in terms of answering that question. It's more
well,
of
I'm sorry, I didn't mean to talk over you. We're talking about conforming guidelines set by regulations. So in the case of a hard money loan or a seller doing something like that, maybe he's got a brother who can give a loan that's a hard money loan, then you're not really falling into the CFPB regulate, but I could be wrong. I don't know because I don't usually answer those questions, but I would say it's a gray area for sure.
Okay. All right. Some of these I think that I will answer in the chat or get with people one-on-one just to confirm. If anybody will give you kind of another 30 seconds to throw in a question here, but otherwise I'll stay in the chat a little bit longer to try to answer. And I just want to thank everybody for their time. Sylvia, wow, so much I didn't even know. Lisa, thanks for taking time on the escalation clauses. Paula, thank you for sponsoring and even answering some of my questions leading up to this that I wasn't sure how a lender would view it. You are a wealth of knowledge and we're so grateful for you. And with that, again, I think I know up at the top of the chat, I put my contact information. I'll put it in there again. If you have questions offline, I mean, this is why we're involved. This is what we're doing. You know, we want to help you serve your customers and be a resource for you. So please reach out to those of us with questions. And if we can answer them, we will. Okay. I'm going to mute and turn off my video and try to answer a couple chat questions. Thanks, everyone.
thank you. Have a great day. We're going to close this out, Erin? Okay.
Okay.